Thank you everyone for joining us. I am Thomas Vick. I am the attorney at Vick Law PC. We are an estate planning, estate administration, and elder law firm. And today's topic is estate planning essentials. We're going to talk about some of the documents that we think everybody needs to have. And we hope that this will be an informative session, hopefully answer some questions for you, and also maybe it will raise some questions in your mind that you want to seek further guidance on. So I appreciate everybody joining us for this webinar. Estate Planning Essentials. Well, to address this topic of estate planning essentials, we really need to understand what is a person's estate. And it's a really broad definition, but an estate is any interest that you own in real property, which includes land and attached buildings, and personal property, which is basically everything else. So you got your house, you got maybe some other kinds of real estate, and you got bank accounts, you got retirement funds, personal property, all of that consists of your estate. So estate planning is really dealing with the transfer of that wealth from one generation to the next generation. And it's important that we plan ahead. There are a lot of different reasons why it's important to plan ahead, but here are some of the common ones that a lot of clients have. First of all, it's important to plan ahead because you need to protect yourself and provide for your spouse and your children. That's probably priority number one for a lot of people, is to protect the spouse and to make sure that the children have something when the parent passes away. Another reason to do estate planning is to avoid family conflicts. Parents know their children really well, and if they want to leave an inheritance to the children, sometimes they know that the children may need a referee. And so you want to make sure that you provide for specific instructions for your family so that they know how to deal with the estate. They know how to deal with the inheritance and who is supposed to get what. And so there's no bickering at the end during a time of grief. Another reason to plan ahead is to provide for special needs individuals. There are specific rules that special needs individuals have to comply with, and it's important that when they receive an inheritance, that their inheritance isn't going to cause them to lose their government benefits. So that's a reason to plan ahead. And another reason to plan ahead is to leave a lasting legacy. Maybe it's a contribution to a charitable organization, such as a church or a different kind of charity. But that's another reason to plan ahead. And the only way that is sure to be accomplished is through estate planning. So what documents should we have at bare minimum? First of all, a last will and testament is important. And it's preferable to have a last will and testament with a contingent special needs trust. Perhaps a child is not a special needs individual now, but due to the uncertainty of life, that child could become a special needs individual. And you want to make sure that there's an outlet for that inheritance to go through so that government benefits are not lost as a result of an inheritance. Another document that everybody needs to have is a durable financial power of attorney. This is a document that authorizes an individual to act on the behalf of another in certain areas, mainly financial areas, dealing with financial accounts and dealing with real property transactions, things like that. You have to have a durable financial power of attorney in place, or a guardianship. And a financial power of attorney is much easier than the cumbersome nature of a guardianship. Healthcare power of attorney, this kind of runs hand in hand with financial power of attorney. It's important for everybody to have a healthcare power of attorney with a HIPAA authorization so that your loved ones will be able to act on your behalf in dealing with doctors and nurses, medical providers, when you're not able to do those things. So healthcare power of attorney is really important. And then a living will, which states your preference as to end of life decisions. Those are documents that I think everybody needs to have at bare minimum. Let's talk a little bit more in detail about the last will and testament. A last will and testament is a written document that's signed in the manner prescribed by law and which disposes of property upon death. Here in Indiana, Indiana requires 2 witnesses who watch the testator or the testatrix sign the will while in his or her presence. You're a testator if it's your will and you're a male. You're a testatrix if you are the maker of the will and you're a female. So it needs to have that, and then it's important to have a self-proving affidavit that proves that this really is the will and I really meant to sign it. And there's some specific language that needs to be there. But basically, the testator and the witnesses will sign the will 2 times, in the witness attestation and then also in the self-proving affidavit. A will is important for a lot of different reasons. It nominates who you would like to be responsible to administer your estate when you die. We call that a personal representative who deals with the estate. A will can also nominate guardians for minor children. So if parents predecease their children while the children are minors, then it's important to know who the parents want to be the guardian of the kids. And you do that through an individual's last will and testament. The will can also determine when and how your devisees, your beneficiaries, are going to receive the property you leave to them. And then it can determine how taxes are going to be paid, if there are any taxes that are owed. And it can employ tax saving strategies as a result. So those are some of the reasons why a last will and testament is important. A will must be probated before it becomes effective. It becomes effective after your death upon sufficient proof that it is your last will and testament. There has to be a court determination that is essentially what it means to probate the will. A court determination that this is the will that this individual signed. And then there's some level of court oversight in administering the will and making sure that the property goes to the right people. And it's a public process. People have access to the records of an estate administration. Here in Indiana, within 2 months after the probate of the will, an individual is, the personal representative is supposed to file a verified inventory that discloses all of the property of an individual, of the decedent, on the date of death. And so that's a publicly available inventory. And so it's a public process, and that may not be what an individual wants with a last will and testament. But that is what the law requires at this point. And then a will does not provide any help for you while you're incapacitated during your life. So sometimes we do a lot of planning for death, but what about planning for those years prior to your death? A last will and testament doesn't really provide any protection for an individual at that stage in life. But a trust may. A trust has some advantages to it. A trust is a private agreement between a settlor and a trustee. The settlor is the one who sets up the trust, and the trustee is the one who manages the trust assets. And the trustee will do so in certain ways for the benefit of a beneficiary. A trust can be revocable or irrevocable, meaning revocable means you can change it. Irrevocable means that you cannot change it. A trust can have more than one beneficiary at a time. It can be written or oral, and it can also include a trust protector provision, which is kind of somebody that makes sure that everything in the trust is running properly. And if it's not, then that trust protector can make some changes to the trust, sort of like an overseer to the trust. So that's what a trust is. And there are certain kinds of trusts do certain kinds of things. Special needs trust, sometimes called a supplemental needs trust, protects an individual's right to government benefits. So it protects a disabled beneficiary's eligibility for government benefits. It provides for a higher quality of life to those special needs persons, provides a framework for care and management of assets. It allows for parents to express their desires for how they want their child to be taken care of. It can kind of spell out some language for what the trustee is supposed to do. One common thing is to make sure that the child who has special needs goes to certain family events or certain recreational activities. And there can be instructions to the trustee that says, I want those things to happen, and to make sure that takes place. It protects assets from creditors and predators. Sometimes the special needs individual just needs some help with financial management, and we don't want assets to be squandered whenever the parents pass away. That's one reason to set up a special needs trust. Another reason is to extend the life of assets. Maybe there'll be a distribution at age 25 and then another distribution at age 35. That may be a reason why a person sets up a special needs trust. Another document that I think everybody needs to have is the durable financial power of attorney. This is a document that empowers your agent to act on your behalf in financial transactions. So if you're not able to make those financial transactions on your own, you can have somebody, usually a loved one, a son or adult son or daughter, who will step into your shoes and handle your banking transactions and things like that. Power of attorney can be either what we call a springing power of attorney or an immediate power of attorney. A springing one requires proof that a certain condition has been met, usually that you are now incapacitated. And typically that is through the determination of a doctor. A doctor will say that this individual can no longer handle his or her affairs, and so somebody needs to step in. And if you have a power of attorney in place, then that's when the power of attorney becomes effective. But sometimes parents are already close enough to the point in time where they need the child to handle matters for them. They feel comfortable with that. They may want it to be an immediate power of attorney. And in that case, the attorney in fact, that person that you've asked to serve in this role, immediately has the authority to act on your behalf. And it's a durable power of attorney because the power of attorney stays in effect after the principal becomes mentally incapacitated. So even though an individual is no longer to consent to certain transactions, the power of attorney still remains in effect. And so it's a really important document, and you really have to be careful with the ones whom you select to serve in this role, because it's such a powerful position for an individual to serve in. The healthcare power of attorney with a HIPAA authorization. This is a document that empowers your agent to act on your behalf to make medical decisions. It also authorizes this person to make end-of-life decisions. And just like the general durable financial power of attorney, this power of attorney can be either springing or immediate. Again, the springing power of attorney requires proof that you are incapacitated, and an immediate healthcare power of attorney allows your agent to act on your behalf whenever needed. So that's a really important document. If you're not able to consent to certain health care, you'll want somebody else to be able to advocate on your behalf through your healthcare power of attorney. And while I'm on the topic of powers of attorney, and I mentioned this a little bit at the start of the webinar, it's so important to have these documents in place, healthcare power of attorney and the financial power of attorney, because if you don't have those things and you become incapacitated, then your loved ones are going to have to set up a guardianship in order to be authorized by a court to act on your behalf. And that is a cumbersome legal process that you would like to avoid. You set up the powers of attorney so that you don't have to pay the expenses of a guardianship fee, an attorney fee to set up the guardianship. So those are important to get put in place as soon as possible. And then a living will. A living will works in coordination with the healthcare power of attorney. The purpose of it is really to state your preference on end-of-life decisions regarding nutrition and hydration when death is imminent. In Indiana, there's a statutory living will that basically says whenever I am on artificially, on life support and my life is being preserved by artificial processes, then I authorize my healthcare power of attorney to withdraw those life-prolonging procedures. And then it gives your preference as to whether you want nutrition and hydration during that time period or you don't, or if you defer to your healthcare power of attorney. So it's important to have that because it states your preference. It makes it very clear to your loved ones what you want to see happen. So those were basic estate planning documents, and just kind of put a bug in your ear about comprehensive estate planning. So comprehensive estate planning would include all those documents we've talked about, but then you might also want to consider a standalone trust if it's appropriate, whether that's a special needs trust, whether it's a revocable trust or an irrevocable trust. And an irrevocable trust can provide some benefits from a Medicaid planning standpoint or from a VA pension standpoint. Those topics are not for today, but there's a lot of opportunity to protect assets from Medicaid, from the government, when you have a Medicaid asset protection trust or a veterans asset protection trust. So just kind of keep that in mind as well, and be looking out for future webinars and future materials on the website and on my newsletter, talking about Medicaid planning and VA planning. So what documents do I need at minimum? Last will and testament, durable financial power of attorney, healthcare power of attorney, and I would say a living will that states your preference as to end-of-life decisions. Are there any questions? Let me stop sharing here and let me see if there are any questions. I appreciate everybody tuning in. Again, I'm Thomas Vick. I'm the attorney here at Vick Law. Sign up for my newsletter. You can sign up for my newsletter by going to my website. Once you're on the website for a few seconds, there will be a pop-up box that allows you to sign up for the newsletter. And we try to do these webinars every month, try to put out information about estate planning, estate administration, and elder law. Try to be a resource to people. My newsletter has a lot of up-to-date current information regarding these topics. And like I said, these webinars, we try to do at least one per month. And then in our newsletter, we have a lot of resources from previous weeks and months that you can look at. So I think we will stop right here. Appreciate everybody tuning in again. If you have any questions, feel free to call my office, 317-884-3133. Thank you so much.